How much is your personal injury case worth at trial? The answer might surprise you. Your personal injury case may be valued differently depending on what stage of the claims process it is in. Your case may have less value early on before you complete your medical treatments. On the flip side, the value of your case may increase as more time passes and you receive more treatments for your injuries. One thing that may greatly affect the value of your case is whether you want to settle the case without filing a lawsuit, or if you want a jury of your peers to determine the true value of your case at trial. I'm going to go over some of the most important factors affecting the value of your case if you take it all the way to trial. First things first, who is the plaintiff? At trial, it will matter a lot who the plaintiff is and who the plaintiff isn't. Imagine if you were on a jury and the plaintiff who had been badly injured in a motor vehicle accident was none other than LeBron James. Imagine his injuries were such that he could no longer play sports or do endorsement deals. How do you think the value of his personal injury claim at trial would stack up to a mere mortal like one of us? His damages are likely to be much higher than a middle-aged salesman, for instance, right? So let's talk about some of the factors the jury will look at when assessing the value of plaintiff's claim at trial. First, will the jury like the plaintiff? Is he or she a likable person that the jury will connect with? Or is the plaintiff someone who will inherently rub the jury the wrong way? The age of the plaintiff is a factor. If the plaintiff is too old or too young, that can affect the value of the claim at trial. The ideal age range for a plaintiff is 25 to 65 years old. Plaintiff's educational background is also a factor. The more education, the better. Better educated plaintiffs generally present better in front of a jury and generally can establish much more significant damages. What does the plaintiff do for work? Does he or she have a significant income? Those could be critical issues at trial. How solid is the plaintiff's employment history? It's important. It tells the jury something about who the plaintiff is and how reliable and trustworthy that person is. You guessed it, appearance is also important. Like everyone else, juries make decisions about people based off of appearance. A well put together plaintiff makes a difference at trial. The plaintiff's prior health is also a factor. The value of a personal injury case is all about the quality of life and how that quality of life has been affected by the accident. As a result, the parties closely dissect the plaintiff's prior medical records. If the plaintiff had similar pain complaints prior to the accident, the defense will attempt to seize on those issues at trial. Or did the plaintiff have pre-existing medical conditions that were asymptomatic before the accident, which then became symptomatic as a result of the accident? If that's the case, the plaintiff's attorney will make sure the jury understands that the accident caused those pre-existing medical conditions to become symptomatic when they never were before. Non-accident related problems may also affect the value of a case. Has the plaintiff had health problems subsequent to the accident that are also contributing to a decline in his or her quality of life? Has the plaintiff had any subsequent auto accidents? Subsequent accidents can create significant problems for a plaintiff's claim at trial. The defense attorneys will do everything within their power to convince the jury that the subsequent accident, not the original one, is to blame for plaintiff's injuries. A plaintiff's criminal history can also affect the value of a case. If the plaintiff has prior felonies, those convictions may be an issue at trial. Do the felonies involve crimes of dishonesty? Those can be a big deal for a jury at trial, especially if the jury is required to make a judgment call on whether the plaintiff is trustworthy. Who is the defendant? This question is also important at trial, although not nearly as important as who the plaintiff is. Is the defendant an individual or a company? If the defendant is an individual, the same factors will be at play that we discussed for the plaintiff, namely the defendant's age, educational background, appearance, employment history, criminal history. As mentioned, those factors are not as important for the defendant as they are for the plaintiff, but they still can affect the claim. Is the defendant a government entity? Historically, juries do not like claims against government agencies like police departments, municipalities, cities, although some of that has been changing with recent events. Maybe the defendant is an insurance company. Juries do not like insurance companies, so that could be an important factor in the right case. Let's talk about venue and the judge. Venue and the judge are also important factors. The venue of your case can make all of the difference. If your case is in federal court, that will certainly affect the value of the claim. Federal court requires a unanimous jury verdict, unlike state court, and it draws from a much broader jury pool geographically, which makes it more difficult to have a good sense about what type of jury you're going to get in federal court. Also, there is no right to voir dire in federal court, which can be a significant limiting factor at trial. What about the judge? Does the judge limit voir dire? What kind of evidence does this particular judge allow in opening and closing? Does the judge have a bias for the defense? Maybe for the plaintiffs? Or maybe the case is in binding arbitration. Arbitration is quicker and more efficient, but the awards generally tend to be much lower. Let's talk about liability and causation. Liability and causation are critical factors affecting the value of your case at trial. Is liability disputed by the defense? If so, do you have favorable witnesses? If liability is disputed and you do have favorable witnesses, the case is more valuable than if the defense simply admitted to liability. What if you do not have any witnesses on a disputed liability case? That is difficult and could make your case tough at trial. What if there are witnesses but they are not favorable? We might be able to deal with one unfavorable witness. Two is much more difficult. More than two unfavorable witnesses becomes very tough to deal with at trial. Let's talk about causation. Defense attorneys love to fight over causation. It's a legal element of plaintiff's injury claim, requiring the plaintiff to prove that the accident was the proximate cause of his or her injuries. In defending the causation element of a plaintiff's claim, the first thing defense attorneys look at is when the plaintiff's symptoms first started. Did the plaintiff tell the officer at the scene of the accident that he or she was fine or that no one was injured? Or alternatively, did the officer note any of plaintiff's symptoms or injuries in the police report itself? Did the plaintiff immediately go to the urgent care or the ER? If so, do those records reference the accident and plaintiff's injuries or symptoms? If plaintiff's injuries show up early in the records for the case, i.e. the police report or ER records, that can greatly increase the value of plaintiff's case at trial, especially if there is a consistency of diagnosis throughout all of plaintiff's medical records, from the first medical encounter following the accident all the way to the last. Let's talk about expert witnesses. The quality and quantity of expert witnesses at trial is important in disputed liability cases. Are the plaintiff's experts as good as the defendant's experts? Do their opinions hold up on cross-examination? Will the jury like them as much as the defendant's experts? Maybe one of the experts did not do reliable work, and the defense is able to convince the judge to prohibit that expert from testifying at trial on a motion in limine. Or alternatively, maybe the plaintiffs can prove that one of the defendant's experts is nothing more than a hired gun who will say anything for money. Maybe the defendant's attorneys have a long history of working with that particular expert because he will say what the defense attorneys want him to say because they send him so much work. Okay, let's talk about comparative fault. It can destroy a case at trial. Comparative fault looks at whether the plaintiff is also at some fault for the accident. If the plaintiff has too much fault in a case, it can be devastating. Juries do not like to award plaintiffs money if they played a significant role in the accident. But remember, in Utah, a plaintiff need only prove that the defendant is at least 51% liable to recover damages. So while a plaintiff's comparative fault may affect the overall value of the claim, it does not prohibit the plaintiff from recovering an award at trial, so long as the jury determines that the defendants are at least 51% liable. Let's talk about aggravating factors. Are there any aggravating factors at issue in the case? Aggravating factors can greatly affect the amount of money a jury will award at trial. For instance, was the other driver distracted, maybe texting or otherwise using his or her phone? Juries do not like distracted drivers and will increase the amount of the award in a plaintiff's favor at trial. Was the defendant under the influence? Of course, juries are especially sensitive to accidents caused by drivers under the influence. If the defendant was impaired at the time of the accident, you can expect the jury to punish him or her at trial with a substantial verdict in favor of the plaintiffs. Did you know these factors can dramatically increase the value of a personal injury claim at trial by as much as 20, 30, 50, or even 100%? There are also a few miscellaneous factors that could play big at trial. Did the plaintiff get too much medical treatment for his or her injury, or maybe not enough? Was the plaintiff's treatment self-procured or attorney-referred? Defense attorneys love to make a big deal out of this one, suggesting to the jury that the plaintiff's attorney is somehow orchestrating unnecessary care. That's not true, but defense attorneys will try to make a big deal out of it at trial. Does the claim involve a workers' compensation crossover claim? That can be a negative factor at trial affecting case value. Does the plaintiff's claim involve psychological claims? Anxiety, PTSD, depression, negligent infliction of emotional distress. Those claims are hard at trial and can be difficult to prove. Juries generally do not like them. If you would like to discuss the value of your case, please give me a call. I would be happy to go over it with you in greater detail without charge.